And our guest of the morning is Mr. Sumit Chander. He's advocate in Supreme Court of India as well as in Delhi High Court, and he's graduated from Kurukshetra University and got his enrolled in Bar Council in 2002. He's expertise in civil, commercial, and constitutional cases. He's frequently invited as a legal expert in various news channels like NDTV, Aaj Tak, and India Today, and so on, and in various legal conferences. He has been appointed as the arbitrator by High Court of Delhi. He has been awarded the National Law Day Award by Dr. Justice K.G. Balakrishnan, former Chief Justice of India. So today, it's our second day and the third season. Today, we would like to take the opportunity to hear the sir. A very good morning, sir.
Good morning, and thank you, Apurva, and most thank you to Mr. Rajendra Singh. This is a very good topic that you all have chosen, pleading and legal drafting. And I will now show this by way of a presentation as to how pleading and drafting can be done. What are the basic things that you need to keep in mind? First and foremost, before even I begin, I would like to just tell all of you that somewhere people think that drafting is some kind of a rocket science. You don't know how many years it takes to do it. No, it's not rocket science. Let us begin with this. Once I explain it to you, you will understand it is simple. Of course, it needs a lot of hard work. It needs a lot of patience. And that is why it takes a long time to become an expert in it. But if you follow these basic principles, which I am going to tell you now, you will be able to learn this and become good at your drafting. You will be able to improve it with time. So let me start the presentation for all of you. Now, is the presentation visible to all of you? Right. So, pleadings and legal drafting. Let us first understand what are pleadings. Pleadings is defined under Order 6, Rule 1. And it will be very nice for all of you if you are able to take your notes at this stage. Now, pleadings have been defined to say that it includes the plaint and the written statement. Once the plaint and written statement is filed, the pleadings are complete as per Order 6, Rule 1. Of course, if in the written statement some new facts have been brought in, then that can be recounted by way of a replication, which will form part of the pleadings again. But so far as Order 6, Rule 1 is concerned, it only includes under the law, the plaint and the written statement. Now to begin, even before we begin understanding how to do the drafting, it's very important for you to understand what is the court procedure. What is it that you see in the courts? What are the requirements under the law when you appear before the court? And if you know this, if that is clear, you'll be able to understand how to draft whatever you intend to draft. Anything, be it an application, be it a plaint, as I just defined under Order 6, or any other document. The first thing that is filed in the court is the plaint. The court accepts the plaint when it's filed. It hears the arguments on the plaint, and if it feels right, it admits the case. Once the case is admitted, they issue notice to the other side. The other party then appears, who will be the defendant, and the defendant is going to file his written statement. Like I said, if there are some new facts brought into the written statement, the plaintiff will again be given an opportunity to file the replication, which will be a reply to the written statement. Once the pleadings are complete, and that is the stage where we say the pleadings are complete, then the court says that you please go and file your affidavit of admission and denial. The affidavit of admission denial is defined under Chapter 7, but I'm not getting into the details of that at this stage. Now, but the purpose of this affidavit of admission denial is that once you file your plaint along with all the documents, and similarly the written statement with all your documents. Then both the parties are given an opportunity to see the documents of the other side, and if they feel that yes, there is a document that can be admitted at this stage, then they may admit it, so that the court time is saved, and the other party doesn't have to go on proving that document, because once admitted, it will be deemed to be proven. So this helps making the process much faster. Then comes framing of issues. Now that documents have also come on record, the court will now sit down to frame the issues, and the court will decide what are the issues that this court is going to adjudicate upon. Now, what are issues? Issues are where a statement is averred by one party and denied by the other, it becomes an issue. So similarly, you will see what has been averred in the plaint and denied in the written statement, or averred in the written statement and denied in the replication if there are some new facts. On these bases, the issues are framed. Now the court does one more very interesting thing here. What the court does is, with each issue, besides each issue, it's going to write OPP and OPD. Now what is OPP and OPD? OPP is onus of proof on plaintiff. OPD is onus of proof on defendant. Now friends, it's very simple. With each issue, the court also makes it very clear who is going to prove what. So maybe the first issue is to be proved by the plaintiff, the second by the defendant, and so on and so forth. Now once the issues are framed, the trial begins. That means the courts now ask the plaintiff, and it begins always with the plaintiff, to file his evidence. With the amendment of 2002, the plaintiff can now file his evidence by way of an affidavit. That will be cross-examined by the defendant, and once that is done, the plaintiff's evidence will stand concluded. After that, the defendant will file his evidence by way of an affidavit. The plaintiff's counsel is now going to cross-examine him, and the defendant's evidence will also conclude. Once the evidences are concluded for all the witnesses of the plaintiff and all the witnesses of the defendant, the case will now be heard by way of arguments. After hearing the arguments, and where both the parties, both the counsels, will bring to the notice of the court how each issue has been proved by them through the evidence, which may be oral or documentary. Then, considering all the facts, all the documents on record, and all the evidence which goes on favor of the parties, the court is now going to pass a judgment. This is the entire process that takes place in the court. Now with this, you've understood the procedure, the basic procedure that takes place. Of course, there are a lot of applications which are moved in between, but overall, this concludes the proceedings in the courts. Now let us understand drafting of a plaint. Like I said, it's no rocket science. There are certain basic principles that you need to follow. So even before I begin, let me quote something very interesting. There's a quote by Shannon Hale, who says, "I'm writing a first draft and reminding myself that I am simply shoveling sand into a box so that later I can build castles." It's so true. When we make our first draft, we have considered all the documents, what the client has told us, and we start collecting those data and just putting them into one place so that we can later frame and make a good drafting out of it. Then keep in mind, it's very important to be specific in your drafting. There's a nice joke on this. So for example, if I offered you, say, $100,000 to jump off a plane without a parachute, would you do it? I bet you would say no. But what if I told you that the plane was on the ground floor? Moral of the story, know all your facts before you open your mouth. The problem is, we as lawyers, initial stages, we have a tendency to hurry up into drafting. Never do that. Collect all your data as much as possible. Give a patient hearing to your client. And only when you've collected and corroborated all the data that you have, you begin with your drafting and you will never go wrong. So my entire process, which I have evolved over years of practice, is only about how well you can collect and corroborate that data so that you begin with your drafting and conclude it in a much more efficient manner. So let's begin with drafting of this plaint. I have divided this into 4 categories or stages, I would say. Stage 1, paper sorting. Stage 2, client meeting. I'll go into the details of each stage. Stage 3, legal research. Stage 4, rough draft. And once that is done, then you prepare the final draft, which can be called a stage 5 or the final stage. Well, let's begin with paper sorting. Now, what is this paper sorting? When the client initially comes to you, he will give you a bundle of papers and a background of his case. He'll just tell you what all has gone through him. Listen to him. Listen to him carefully and draw a sketch in your mind. And with the bundles of papers that the client has left, now you start studying them and put the date of the document on the top right corner of each document with a pencil. I say with a pencil because you may want to delete it tomorrow before filing it in the court. That's just a technical part. But it's very important to write the date of each document on the top right corner of the document so that you are able to be very sure that you have sorted those papers date-wise, and then you start studying these documents carefully. Now, very interestingly, when we begin with putting the date of the document, a lot of it may sound very simple, but let me tell you what kind of problems we face. One, document may have, say, for example, it's a letter which is dated, say, 26 June 2020. But towards the end of the document, the client ends up signing it and putting a date below, say 27 June 2020. Now, which one would you say is the date of the document? Well, friends, you will put the date when it is signed, or when you're drafting, you're going to be very particular about it, where you're going to say that the document which is dated this and signed on this is the document I'm referring to. But so far, for the purposes of sorting out the documents date-wise, you must take the date of the document on which date the document was executed. Now, when you have put all these documents in a sequential manner, starting from the oldest on the top, then you start reading this like a storybook, from the old to the new, from how it began to how it is today and how it's expected to go in the future. So now you start studying, and you can be very sure, because you've already sorted them date-wise, you can be very sure of the sequence of these documents so that your storyline in your drafting becomes clearer. Now, while studying, you make a list of dates, events, and the source of information. This is a basic format which we use to prepare. On the first column, you write the date. In the second column, you write the event. And last, you say the source of the document. Now, source of the document, you can say it is the document which has given you the date. Say, like, for example, the letter dated 26 June 2020, the example of which I gave you. Or it may be a letter of 26 June 2020, but in the letter, it has mentioned that in the year 1990 such incident had taken place. If that is the case, then the source of the document will become mentioned in the letter dated 26 June 2020. So that's how you make this list of documents, list of dates, and this will get elaborated with not only the date of the document, but also the dates mentioned in the document. Then you call your client for a meeting. When you call your client for a meeting, ask him for a story along with dates. Don't tell him that you've already done your research so far, but keep that handy with you. Now, when the client will start telling the story, invariably you will find the dates don't match, because rightly so, the client is speaking with a lot of emotions. Now, keeping those things in mind, you confront him when his story does not match with your list of events that you have prepared. Confront him with the documents. And when you do that, you will see that the client agrees with you and says, sorry, you were right. This so-and-so incident did not happen on so-and-so date. It happened on the date which you are mentioning. Now make a note of his list of dates and fill it in the gap in your current list of events. So now your same document will now increase to have three things. First was, of course, the date of the document, the title of the document. Second was that it is mentioned in so-and-so document. And third event will become the information received from the client. So that when we are preparing our draft, we know for sure that the client has just mentioned it. We don't have any evidence to support it. We don't have any, at least documentary evidence to support it. And we will have to take help at the time of evidence when we cross-examine. So that's how you know how strong or weak your case is, that of your client. In stage 3, now that our list of dates is completed, we do the legal research. We search for the relevant judgments through books, through precedents, through, now you have a lot of softwares. Once your facts are very clear in your head, you should see whether the judgments or the precedents that you're now reading, do your facts are supported by those judgments? So that tomorrow when you're arguing in the court, you're very sure that if a thing goes wrong, I'll be able to convince the judge that, listen, similar facts had taken place in so-and-so case before the Honorable High Court or the Supreme Court of India, and the Supreme Court held so-and-so. Then, very important thing, read the relevant provisions of law. Say, for example, a simple check bounce case. I may have done several of them. Initial stages of our career, we do a lot of these check bounces cases. I don't do them anymore. But every time I would do it, I would read Section 138 Negotiable Instruments Act. And every time I would read, trust me, it gives us different interpretation altogether. Similarly, now if you do a constitution, a PIL, under Article 226, 227, I would definitely read Article 226 again. So every time you're drafting a case under certain provision of law, please read that provision of law. Then note down the ingredients of law, at least in point wise, make pointers of it. I will give you an example how. Say, for example, Section 138 of the Negotiable Instruments Act. Now, this act, all of you are aware, says that where any check is drawn by a person on an account maintained by him with a banker for payment of any amount or money to another person from out of that account for the discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds arrangement, it exceeds the amount arranged to be paid from that account by an agreement made with the bank, such person shall be deemed to have committed an offense, and so on and so forth. Now, reading this much, I've put that in bold the relevant portion. Can you take out the ingredients of this section? Possibly if this was a live session, I would have asked you to tell me the ingredients. But since we are doing it online, I will tell you what are the ingredients made out. But you must do this exercise with other provisions of law. Do it out of interest. You will obviously learn something. So the ingredients which comes out of this: one, that the check should be drawn by a person on an account maintained by him. Second, it should be made for the payment of any amount of money to another person. Third, it should be for a discharge in whole or in part of any debt or other liability. And it should be returned by the bank unpaid or either insufficient of funds or exceeds the amount arranged. So in your drafting, you must ensure that your facts cover these four things if you are making a complaint under Section 138 of the Negotiable Instruments Act. That's how your drafting on facts, combined with the provision of law and supported by a precedence, will become a perfect draft. But yes, these things take time. That's all you need to do. So with this, keeping these three things in mind, make the rough draft, keep the final list of dates in hand, which is your facts, name the title. The title of the case would be obviously either with a plaintiff or a defendant. In a check bounce case, it will be a complainant and an accused. It will be so that's how it goes on. In a petition, it's going to be a petitioner and a respondent. Draft the paras introducing the plaintiff and the defendant. This is very important. Initial stages, you must introduce the initial paras. What is the plaintiff and his nature of work? What is the defendant, his nature of work? And why this transaction has taken place between both of them. Put the final list of events in a story mode and write the mandatory paras as per the facts of the present case. Now, what are these mandatory paras? Now, mandatory paras have been defined under Order 7 of the Code of Civil Procedure. Some basic things that you need to put at the end of your drafting, at the end where you have put on all your facts, you've introduced the plaintiff and the defendant initially, you put on all your facts, and last you put these paras, obviously based on your facts, but you must tell the court how the cause of action has arisen in your favor, why this court has the territorial jurisdiction to entertain your case. So you'll have to say so and so action has taken place within the territorial jurisdiction of this case, your court. Third, the pecuniary jurisdiction. Every court has a pecuniary jurisdiction. Depending as to what the amount is, it may go to the High Court, the District Court, or the Civil. The limitation. What is the limitation in your case? If it's a suit, it will be for 3 years. If it's for check bounce, then you know the limitation prescribed under Section 138. And you must mention that yes, you have complied with, and this case falls within the limitation period and hence covered under the mandatory requirements of Order 7. The value of the suit and the court fees are fixed. It is very important for you to affix the proper court fees and accordingly value it properly, because if objected, your case can be dismissed under Order 7, Rule 11. And last but not the least, the prayer. It's very important to have a specific prayer. Then comes to the final draft. Once all these things are ready, so keep your file so that you can refer to the documents. Keep your list of events and that rough draft with you. List of events will help you understand which points are now supported by a document so that you can make them an annexure. But it's not always necessary to use all the documents given by the client. You have to use what are relevant for this case. Then give a final reading to your draft. Check that there should be a very clear storyline. There should be no grammatical errors. Little things in life matter. How you present your case before a judge matters. It talks a lot about the lawyer who has drafted it. So please check for these grammatical errors. Ensure that there is no missing link. Now the story should be in a very clear one after the other events. There should not be any missing events. Say for example, there was this very interesting serial which used to come earlier, and there was one very interesting thing that happened there. The serial used to call MASH, M-A-S-H. It was a army thing where once in the cantonment area of one of the parties, the missile comes and drops but doesn't blast. So they immediately call up they don't have a bomb squad there. So they call up their head office and they find out, sir, we have a missile bomb which is now lying in the premises. It may blast any time and we don't know how to defuse it. So the head office, the headquarters tells them that please, we will give you the instructions from the expert and you defuse them accordingly. So on the phone, the instructions are coming and they begin with, there'll be 3 wires, the yellow, green and red. Cut the green wire first. They cut the green wire. Now see how the difference comes in when there is a link missing. So this chap was not good with his drafting. So what he does is he says, cut the red wire now. The moment he cuts the red wire, the missile blasts. There's a bomb explosion. And then on the phone, on a crackling sound, the voice comes, but do not forget to cut the yellow wire first. So in your drafting, make sure that you go one after the other. If it's green, red, if it's green, yellow and red, write green, yellow and red. Don't say it's green, red, and then don't forget to put yellow before the red. So your link should be one after the other and there should be no missing link. Ensure that all the ingredients of law are fulfilled and make the supporting affidavit. Now, once your pleadings are complete, you must support it by way of an affidavit, which has been defined under Order 6, Rule 15, Sub-Rule 4. Now, what is the contents of this supporting affidavit, which goes with all your pleadings? Order 6, Rule 15. In this affidavit, the plaintiff, that is your client, he must say how he is competent to depose. Of course, he's a plaintiff, he's aware of the facts, and that is why he's competent to depose. Second, that whatever has been written, though it has been drafted by the lawyer, it has been drafted on the instructions of the plaintiff himself. And third, in case he is illiterate, he does not know how to read, then there must be a para in this supporting affidavit which says that the contents of the accompanying plaint have been read out to me in my vernacular language, maybe a South Indian, North Indian, whatever language it is, and has been understood by me. He must put this on oath. Third, he must say that no part of the accompanying pleading, it may be the written statement or the plaint, is false. And last but not the least, nothing has been concealed therefrom. This affidavit must be attested by an oath commissioner. Keep in mind, it is not the notary public, it is the oath commissioner that has to do the attestation. So basic points that you need to keep in mind while doing your drafting. Keep the language simple. There should be no repetitions. Repetitions tend to contradict whatever you are saying. Third, use the words as much as possible from the documents. Avoid long sentences, because when you make long sentences using and, there, so, you tend to dilute whatever you're trying to say. It becomes unclear. So short sentences are always clear, so avoid long sentences. Pleadings should be very, very specific. There should be no ambiguity. And most important, the prayer should be very specific. Now, there's this very interesting case, which I call the refrigerator case. There was a consumer case a long time back, and this is a true story. So, I was in a consumer forum arguing a consumer case with respect to the refrigerator on behalf of one of the manufacturers. And the company had given me very clear instruction. They said that please settle this issue. In case the customer wants the refund, give him the refund. If he wants a replacement, give him the replacement. So I go to the court, I put this offer before the judge to the customer. Now the customer, who was the consumer in person, the complainant in person, he was very agitated. But again, he was not a lawyer, so his prayer was not specific. So the judge asked him. The judge asked him, so what do you want? They are ready to offer a settlement. He said, Judge Saab, I want to teach these people a lesson. So the judge said, teaching them a lesson is okay, but do you want a replacement or do you want a refund? Again, he said, Judge Saab, I will not leave them. I will teach them a lesson. So, because the prayer was not specific, the judge did not know whether to give him the replacement or the refund. Therefore, no settlement could take place. The case continued. Eventually, he lost the case. So be very clear. Ask your client, what does he want? And that should be very specifically written in the prayer clause of your pleadings. Now, the choice of words is very important. Another very interesting case. What had happened, we call this the gas cylinder case. And this is of Nani Palkiwala, a great lawyer. Now, there was these gas manufacturers who had a problem. What happened was, the gas dealers would bring their cylinders. They would, the manufacturer would fill them in the cylinder, and then they would take the cylinders and not return it for a long time. So these gas manufacturers said that, listen, for the duration that you will keep the cylinder, we will charge you a rent over. And this was basically done not for making extra money, but was to use as a deterrent so that they return the cylinders at the earliest possible. Unfortunately, these it did have an effect. The cylinders would come back fast, but on the money that these rent, which was being given as otherwise a penalty, the government was charging the manufacturers a tax. They said that, see, rent is an income, and on that income you need to pay a tax, which was, of course, across the country going on huge amounts. So they approached Mr. Nani Palkiwala and they asked him that, see, this is a problem we are facing. We are losing a lot of money. Our intention was not to charge these people. It was only so that it acts as a deterrent and they return the cylinders faster. So Nani Palkiwala, he gave them one word. He said, just change the word. Don't call it a rent. Call it the gas keeping charges, the cylinder keeping charges. And that's not applicable in tax. You will save your tax money. And that's exactly what they did. The company saved crores of rupees just by changing the word from rent to a gas cylinder keeping charges. That is the importance of the words that you use in your drafting. So use a proper choice of words is very, very important. Now briefly, I'll tell you about contract drafting also. And contract drafting, rather than getting into the details, let me tell you by way of certain examples. How to be specific. Now, if you were to give an orange to someone, how would you offer it? Very simple. Most of us would say, of course, I would just say, please have an orange. That's a layman. But if you are a lawyer and you know in your pleadings you've got to be specific, in your drafting of a contract you have to be very specific. So the same orange, you would offer it by saying, I hereby give and convey to you all my rights, interests, claims, and title to the said orange, along with all its rind, juice, pulp, and seeds, and all its advantages thereto. Now see, it's the same orange, huh? With full power to bite, cut, freeze, and otherwise eat the same, or in any manner give the same away to any person with or without the pulp, juice, rind, and seeds. Now see how specifically you have offered this orange with all its rights. That is the kind of drafting that you should do while drafting a contract or an agreement, or even in your pleadings. Be as specific as possible. Now, why being specific is so important? Now, let me give you two case examples, a very interesting case examples. A case that took place in the era of Akbar and Birbal. Now, there was this case that came up before Akbar, King Akbar, and they said once a man had sold his well to a farmer. Next day, when the farmer went to draw the water from that well, the man did not allow him to draw the water from it. He said, I have sold you the well, not the water. So you cannot draw the water from the well. Very logical. The contract was drafted very bad, not his fault. And he is very right in saying that, listen, I have sold you the water. Unlike the orange that was offered so specifically, here there was no specific explanation. So rightly so, he said, sold him the well, not the water. So he said, you cannot draw the water from the well. Obviously, he goes to the court. In the court, Birbal is asked to solve the issue. And Birbal comes up with a solution. Of course, using this vague term, his solution was, since you have sold the well to the farmer and you claim that water is yours, then you have no right to keep your water in the farmer's well. Either you pay the rent to the farmer to keep your water in his well, or you take it out of his well immediately. So, of course, Birbal found a solution. But then, if the contract would have been drafted well, if the well was sold along with the water, its contents, and all its rights thereto, this problem would not have arisen at all. Another interesting case where the contract was badly drafted was in the case of Merchant of Venice. Now imagine, this is a 16th century play by Shakespeare, still so relevant in contract drafting. Now in this case, what happened was, Antonio is short of money because all his wealth is invested in his fleet, which is currently at sea. He goes to a Jewish money lender, Shylock. Though Shylock hates Antonio, but he agrees to give him a short-term loan on a condition that the loan must be repaid in 3 months, or he will extract a pound of flesh from Antonio. Antonio agrees, confident that his ships will return in time. But Antonio's ships are wrecked, and the date for the repayment of Shylock passes away. So Shylock now demands the pound of flesh. Can you notice the bad drafting, contract drafting in this? Which is again, of course, taken advantage of. But in this case, he was to give the money in 3 months. Otherwise, Shylock could take a pound of flesh from Antonio, without, of course, getting into the specifics of what comes along with the pound of flesh. So they go to the court, and the decision is taken that Shylock can have the pound of flesh as long as he doesn't draw blood. That's how Antonio was saved. But then again, these are examples of bad contract drafting. If this would have been drafted properly, possibly Shylock would have had his revenge and got Antonio killed by taking his pound of flesh. So, what are the important legal points in agreements that you need to keep in mind. Whenever you draft any kind of agreement, do put on these clauses of termination. You must be very specific how this contract would be terminated, whether by efflux of time, if not by way of a notice, if the notice is given to which address, by indemnification, that in case some loss is caused by the other party to the first party making the agreement, would that loss be covered up by the other party? Would that other party indemnify me? Then the arbitration and mediation. In fact, we put both nowadays. Generally in the contract agreements, of course, after writing the commercial terms which the clients want us to, we write a clause that in case of a dispute that arises out of the construction of this agreement, the parties would first be referred to mediation by a mediator, a neutral mediator, or by the Delhi High Court Mediation Center or any mediation center available. If the mediation fails, then the parties will refer the case to the arbitrator. So with these clauses, we avoid going to the court, we avoid the long time that takes in the court procedures, and we are able to sort out the issue much faster before an arbitrator, and even before that if things get sorted out in the mediation. We must put a clause of jurisdiction. We must say that in case of a dispute, especially in cross borders, cross the states, if there are parties from two different states or two different countries, you must mention that in case of a dispute, the parties would have a right to go to the courts of which jurisdiction. The force majeure clause is very important. We are presently suffering from this pandemic. A lot of contracts which were to be concluded during this period are unable to be completed because of this present lockdown we are passing through. So now this has become a force majeure issue. Courts are taking up, a lot of disputes are arising where people are approaching the court saying that it was a force majeure clause, but whether this pandemic would be covered in this force majeure or not, those are legal issues the courts are looking into. But yes, you must have a clause which said, and now in fact from here on, I'm sure people would include in force majeure, besides of course the earthquakes, the storms, the other acts of gods, they will also include pandemics of the present kind. So keep all these things in mind. You will make a good drafting. Like I said, legal drafting is no rocket science. You can follow me on LinkedIn, Instagram, and Facebook. I'm always there. Any kind of doubts you can ask. And do your drafting well. Repeat. In fact, my senior, when I was interning with him, and I would ask him, so how do you draft? How do you do a good drafting? He said, Sumit, there is only one way to improve your drafting. Whenever you draft something, read. A lot of people don't even give a first reading to their drafting, whatever they make. And trust me, it is boring to read. And it is even more boring to read your own draft. But he said, if you want to improve your drafting, you must read your drafting, whatever you drafted, and you must reread it and then reread it. And trust me, every time you will reread, you yourself will make a change in your drafting. It will come to your notice, and that's the only way you will improve your drafting over the period of time. Of course, this is hard work. This takes time, but doing it, the process is very simple, and you will be able to improve your drafting if you keep following these simple processes. With this, I will conclude, and thank you very much. I hope you have gained from this. Over to you, Rajendra ji and the team. You're on mute, Rajendra.
If you have any question, you can ask or you, in chat box, or you can raise your hands to direct to Sumit sir.
I see Amrita Soni raising the hand.
Unmuted. Unmuted.
I see Dr. Neeraj Sharma also raising hands.
You
Advocate.
can ask question. You can ask question.
Hey, good morning, sir.
Yes. Morning, Dr. Neeraj.
Yes, sir. I would like to ask one question, sir, in that reference. If by mistake, as you have said, by mistake, if some issues taken place in drafting the whatever the content in the legal form, then would there be some remedies to again rectify that?
Yes, there is always under the Code of Civil Procedure, you have the provision for amendment of plaint. You can move an application, take the permission of the court. You can tell the court that these were inadvertently missed out, and you can ask the court, with the court's permission, you can amend your plaint. So that's not a problem. I see compliments from Vishal Kedar, who says excellent session. Thank you so much, Mr. Vishal. I see from Mr. Gurmeet Anand, very nicely and clearly elaborated, sir. Thank you so much, Mr. Gurmeet. I see from Vidya, fantastic session. Thank you, Vidya. I see from Advocate Vishal, I understand each and every point. Thank you so much, Mr. Vishal. Vidya, again, the PPT slides were so easy to understand. Again, thank you. Hemant Joshi, thank you so much, Sumit sir, for a wonderful session. It would be nice, Hemant Joshi from Udaipur, thank you so much. All compliments coming up. Thank you so much, Amrita, Soni, Purvaja,
Chandramouli.
Hello.
I have Chandramouli. I have unmuted you. You can ask a question now.
Yeah. First of all, Sumit ji, I think the presentation was excellent in the articulation. It's a real exhibition of how to articulate very well. Now the question that I have is a little odd. Like
right.
Basically at the time when you filed the petition on the plaint,
right.
It looks like, let's say, it's a civil petition, but
yes.
subsequently if certain criminal activities take place and you have to change it into a criminal complaint, then what is the process that would happen in that case, or how do you draft?
See, if it's the criminal proceedings, what you're talking about is, for example, a perjury situation where the false affidavit or something false has been stated in by way of an affidavit in the case, then of course the perjury petition is fine.
Sorry, sir, I can't hear you.
Okay, am I audible now?
Slightly. If you could just speak up a little bit, sir.
Okay, I'll come slightly closer.
Yeah.
See, if you're, I don't know, it depends as to what you're talking about, but if there is a criminal proceeding arising out of some actions that have taken place during the proceedings of the civil case, then you can move a petition. In case it's a false affidavit which has been filed, you can move an application for perjury that will be taken up by the court in a separate petition. If it's some other kind of a criminal activity that has taken place or during the pendency of a civil proceedings, you can initiate criminal proceedings separately. Both the criminal cases and civil cases can go parallelly.
Okay.
Amrita Soni has a question. I have unmuted you. You can ask the question.
Purva B, thank you.
Amrita Soni.
Kalpana Bharti, thank you. Deepa Rajendran, thank you. Ashish Varshne, thank you. Anuj Gehlot, thank you. Saubhagya, thank you. Rafiq Aziz, thank you. Purvabi, thank you. Bhavya Gupta, thank you.
Sir, can you tell about more about force measure? Students are asking.
So force majeure is a clause. In fact, basically force majeure is the acts of God. There are reasons beyond the control of human beings. Supposing I enter into a contract with you for constructing a certain building or a house, but maybe there is some kind of a, like for example, the present pandemic, which is beyond our control. Government says nobody goes out. Maybe there's a storm, there's a any kind of a thing. There was a tsunami which had come up some time back. So all acts of God which are beyond the control of human beings, and because of that, if a person is unable to comply with the terms of the contract, say for example, I was to complete this house, construct this house within 1 year, but because of this pandemic session or some act of God which went on for a very long time and I was not able to complete it within the given period under the contract, that period can be exempted if there is a force majeure clause. And like Purva B has given this message and asking me to quote the example of the Oh My God movie, I think she's very right. The Oh My God movie is a very good example. If you've not seen it, please see it, where this person challenges the act of God itself. So he challenges the force majeure clause because his insurance claim was rejected once his house was destroyed on the pretext of a force majeure clause by the insurance company, saying that it was an act of God and therefore the insurance company will not be liable to pay any money to this person who had lost his shop. Yes, Sanket says, is drafting procedure for temporary injunction different from the general procedure? This, what I have given you, is a standardized process. Of course, when you're drafting a temporary injunction, you have to bring the facts into place. But like I said, when you read the relevant provisions in a, say for injunction, the relevant provisions would be your order 39, rule 1 and 2. You will realize that you need to put in some more additional clauses under the provision of order 39, saying that the balance of convenience lies in whose favor, and so on and so forth. So these will be slightly, those points will be extra, but yes, the drafting procedure, what I have explained, will remain exactly the same. Thank you, Apurv. Thank you.
Sir, there is a question that if Honorable Delhi High Court has said that the rent has to be paid to the landlords, and we cannot waive out the rent because some person has gone to the Supreme High Court, Honorable High Court, for this, that to waive out the rent.
Right.
High Court said that we cannot waive out the rent, you have to pay. Still, this force majeure clause will be included in these agreements.
Like I said, contract drafting is important, and not all rent agreements have a force majeure clause. So depending on each facts, they said you fight it out accordingly. Now there are contradictory judgments of the Honorable High Court itself, where some courts are saying that yes, this present pandemic will be a force majeure. The others say this would not be. Then the government orders have been coming in. Somewhere the government is saying you allow rent to be waived. Sometimes they say that. So there is a lot of confusion coming up here today. But the focus should remain, so far as a contract is concerned, whether it has a force majeure clause or not. If it has, then the second question comes up is, you can take its advantage, calling this an act of God, and then your interpretation before the court remains whether the present pandemic will be a force majeure clause or not. So that's a separate topic altogether to be discussed. But in short, I can just say for the present discussion on contract drafting, everything will boil down to whether your rent agreement had the force majeure clause or not. Your entire arguments will change on that basis.
Thank you, sir. Thank you, sir. Anyone have question? Please say.
Okay, so Kalpana Bharati wants to know if any person possesses adverse possession since 1966 as a tenant, then he can claim for ownership title. It's a separate topic altogether, but yes, keep in mind, yes, you are right, they can claim adverse possession, but adverse possession, you have to prove how it is adverse. A lot of people think that being in possession gives them the entitlement. That is not the case. You have to show that you were in possession since a long period, but that was objected to, and you have contested that objection, and despite that objection, you continue to stay there. So that's how your adverse possession has come into effect. So if you are able to prove that, yes, you can claim ownership title. Deepa Rajendran wants to know until which stage can amendment be done on pleadings. This is very interesting. So amendments can be done when the trial begins. So there was this very interesting case where we were arguing, when does the trial begin? Does the trial begin when the issues are framed? Does the trial begin when you file your evidence by way of affidavit? So it's actually when the evidence is filed, when the evidence stage begins. So we were arguing very minutely on whether the evidence stage has begun immediately after the framing of issues, or it begins when the affidavit is filed. But definitely the amendment can be done up to the stage where the pleading, where the trial has not commenced. That means the evidence has not commenced. Vidya wants to know, sir, can you enlighten some basic points to be taken care for by arbitrator? Vidya, I'm sorry, I'm not able to understand this question. I'm myself an arbitrator in a few cases. Possibly if you're more specific, I'll be able to answer you. Amrita Soni wants to know, says that very good knowledge. Thank you. Thank you, Amrita. Rafiq Aziz wants to know who will get benefited, owner or tenant in force majeure. The tenant will get the benefit because he doesn't have to pay the rent and the owner can't throw him out. But again, depending as to what are the clauses put in the agreement, rent agreement, that is what is going to matter. The owners would definitely try to use this force majeure. If your question is whether they would be able to use this to throw the tenant out, no, that they won't be able to throw them out on the grounds of force majeure. Rishabh compliments me. Thank you so much, Rishabh. Ayush, thank you so much. Harry English. Firstly, I would give thank you. Thank you, Harry. It's so stirring and highly effective in learning from your speech. My question is very simple. After drafting, where we have to file the case or the complaint, and how will we decide the case to be filed in the district court or the sessions court or the high court or the Supreme Court? For example, if A wants to obtain the NOC of the vehicle from a financer who says NOC would not be issued until the late payment charges be cleared off. So, see, your question is more of a legal opinion that you're taking. Of course, it will depend on the documents available with you. So, I would recommend you to consult somebody, show him the documents, and then take the advice. But of course, depending as to what case you will prepare or the lawyer will prepare, and what is the pecuniary amount that you've put as a claim, that will decide as to which court you will go to.
Sir, can you throw some light on moot court, preparation of moot court memorials?
Moot court memorials?
Yeah.
It's always good to participate in moot court memorials. I don't know what your question is exactly, but yes, I would always encourage students to participate in moot court memorials and moot court competitions. It's a big learning. It's a huge learning, because to prepare your arguments, you will do your research, you will fall and step into the shoes of a lawyer and prepare it with whatever the best of your ability. And you must do it, because like law, I would say, is not something you learn. Law is a habit that you need to inculcate in yourself. So the more you practice, the better lawyer you become. And that is why no matter how many years into practice, you are always called a practicing lawyer. Vidya wants to know what it takes to be a good arbitrator. Be honest, be sincere, be impartial, be fair to all the both the sides, and of course you should know the court procedures so that you are able to perform and do the proceedings as required under law as it takes place before a proper court. A poor interlocutory application in a suit is not a question. You need to be more specifically asking me whether you want to know how to make an interlocutory application in a suit. I don't know. So Swati Chandra says, good morning, sir. I'm a student. I want to know if I want to practice in a civil court, then which subject should be more strong for my academic? Swati, it's a matter of your interest. You need to see what excites you. Civil cases can also be a wide scope. Now we have civil, also now we have divided that into commercial, whether commercial attracts you, matrimonial attracts you, whether arbitrations attracts you. So you see what attracts you more, what interests you more, and accordingly join the practice. All fields are good. Get from your academics. I don't know if you're interested in PILs and all. Join a lawyer who's a government counsel. See a lot of public interest litigations being filed. Mohammed Fash, very effective webinar. Thank you so much, Mohammed Fash, Sazed Siddiqui. Vidya, thank you. Kalpana, what is the difference between moot court and original court? Moot court is where students get together, make a judge amongst any lawyer, any dignitary, maybe your teachers also, maybe another student. But get along, get with your students. One student can be a judge, two others can be lawyers. Put on certain facts, argue it amongst yourself. That will be moot court. Original court is, of course, where you get money to appear. Moot court, you don't get money by your clients to appear in the moot court. Chandra Prakash Sharma, can WS may be amended? Yes. All your pleadings can be amended, Chandra Prakash Sharma ji, before the trial commences. The trial commences when the evidence stage begins. Deepa Rajendran, according to you, who do you think is a good lawyer or a person who saves his client or the one who abides by the law? Deepa Rajendran, let's be very clear. We as lawyers are officers of the court, and that is possibly the reason why we are exempted from service tax. But yes, a person who is true to the court, who puts the proper facts of the client before the court, is a good lawyer. Of course, you will win a case if your case is strong, but do not conceal anything from the court. The judges are not blind. Don't just go, you're not a mouthpiece of a client. The clients want a lot of things, but advise your clients accordingly and put before the court. You're first the officer of the court. Always remember this. Purva B, dummy court, yes. I think she's answered the moot court issue. Chandra Prakash ji, thank you so much. Pramod Sisodia, does methods of drafting change in International Court of Law? The same things what I've told you, do it with a better hard work. You will be able to, one good thing about international drafting, International Court of Law I've seen is they are very, very clear what they want, very specific. They keep their drafting short. So whatever I've told you will definitely help you do any drafting, be it an international court or in the domestic courts. Can you suggest some textbooks of drafting for law students? I won't, Tejasvi Dudeja, I won't be able to suggest any books. I think your teachers will be the right, or your colleagues would be, your peer students would be the right people. But whatever book you may do, books would only give you certain aspects of drafting, but it's about practice. The more you practice, the better it is. For certain contract draftings and agreements, I think I generally refer to a book by Mr. D'Souza. I have it, but I will have to move off the screen to show you that.